In this lesson, we will cover the foreclosure proceedings specifically for the state of Georgia. In Georgia, when a borrower defaults, the security deed passes title to the lender. Nevertheless, lenders normally use a non-judicial foreclosure method referred to as the power of sale, which gives the lender the right to sell the property in order to recover the unpaid loan balance. When a borrower signs the security deed at the time the initial loan is taken out, the borrower gives the lender the right to sell the property upon default because that security deed contains a power of sale clause. While the foreclosure process in Georgia is a non-judicial process, meaning no court judgment is required, Georgia law does impose strict regulations on the method and frequency of advertising and the timing and conduct of a foreclosure sale. Specifically, Georgia law regulates the following aspects of a foreclosure sale. Who can sell the property? The person or financial institution selling the property of a borrower in default must be the party identified as the lender in the security deed. A lender is allowed to use an agent, an attorney, or a representative. In the event the original lender sold the security deed, the power of sale right which allows the lender to sell the property transfers to the successor, the party who purchased the security deed. If the original lender is a deceased individual, the security deed, along with the power of sale right, transfers to the heir of the lender's estate. Notice of sale. The acceleration clause requires the lender to notify a borrower that the lender has accelerated the loan and is now requiring the total loan amount to be paid in full. To ensure that a borrower has been notified, the law requires a notice of the sale to appear in the official organ of the county once a week for 4 consecutive calendar weeks, preceding the week in which the sale will occur. The official organ of the county refers to the newspaper accepted by the people and/or officials of the county as the source of legal notices. A sale is legally invalid if it occurs in the same week as the last of the 4 notices. Form and content of the advertisement. A great deal of care goes into constructing and publishing the notice of sale because an error in the advertisement of sale could invalidate the subsequent sale. The published advertisement must contain the complete legal description, the name of the lender, the name of the attorney who will conduct the sale, the place of the proposed sale. Usually sales take place on the steps of the county courthouse. However, another location may be used if ordered by a superior court judge, and that new location is applicable to all such public sales. The day and starting time for all sales that day. Because there are typically several sales on the same day, an exact starting time for a specific property cannot be provided. The application of any proceeds of the sale to special purposes, such as the payment of taxes or another lien. Typically, the advertisement also states that the terms are cash, but doing so is not a requirement. The highest bidder may put down a deposit, and a cashier's check is as good as cash, but the highest bidder may be passed over in favor of a cash bidder. The advertisement is also supposed to include the name of the borrower in default. However, this requirement is usually ignored. Conduct of sale. The conduct of the sale is governed by both state statute and the principle of fairness. There is no requirement that the auctioneer be a disinterested third party. The lender can conduct the sale. The sale must be conducted fairly and impartially. If circumstances are not favorable for a fair sale, the lender has a duty to withdraw the property for sale and conduct the sale at another time. The purpose is to obtain the fair market value of the property, However, that legal requirement is typically interpreted to only require an adequate price. Bidders at the sale. Anyone can bid, including the lender and/or the borrower. A bidder cannot act to injure the borrower or any junior lien holders. Confirmation of sale and deficiency judgments. Judicial confirmation of the sale is not required unless the lender wants a deficiency judgment. A deficiency occurs when the sales price of the property is less than the unpaid loan balance and expenses of the sale. For example, imagine that the borrower owed the lender $150,000, but the property only sold for $120,000 at auction. The lender might seek a deficiency judgment against the borrower for the difference of $30,000. If confirmation is required because a deficiency judgment is sought, the lender must file a report of the sale with the judge of the Superior Court within 30 days of the sale. The court then conducts a hearing wherein the borrower can question the legality of the advertisement, fairness of the sale, and/or the adequacy of the sales price. Proceeds of the sale. Sale proceeds are distributed by the party that conducted the sale in order of priority as follows. 1. Costs of the sale, including attorney fees. 2. Primary lien holder, lender. 3. Junior lien holders. 4. Borrower.